Okay,
I'm
it's
sorry, is that
being
me?
live streamed. Hi, James. Yes.
Oh, okay. How
Hi.
are you?
I'm doing good. I'm doing good. Thank you so much. And I hope all the speakers here are doing great as well. So it is live streamed now. So we're going to begin our today's webinar. But before we start, maybe I would like to say hi not only to our speakers, which I already said hi a couple of times during our um, a short brief of discussion. Hi, all participants. Good evening from Jakarta. I hope you all have a very pleasant evening. And I hope that all of you who are watching this are in great health as well, because in certain countries in Asia, especially Singapore, and then I also see several cases in Malaysia as well as Indonesia, is having a great number of increasing for COVID. So I hope that all of you are doing well in this evening. Um, and allow me maybe to introduce myself first. My name is Nadine Sherani, here as the A3T Secretariat. So maybe some of you might think that what is actually A3T? I mean, yeah, we've heard of contrast from Indonesia, and in regards to torture, we've heard of OMCT, and then other organizations from each country or regionally or global organizations. But maybe I would like to introduce our baby organization, which relates and focuses more onto the advocacy of torture. So A3T, or the Asia Alliance Against Torture, is basically a collaborative movement of torture advocacy and how do we abolish the number of torture cases within Asia. So here we have a couple of members from CSOs across Asia, from Malaysia, we have also Pakistan, we have Thailand, we have Bangladesh even, India, and also Nepal, and many other countries within the Asia Pacific. So one of the things that we are also currently focused on, instead or besides introducing our regional collaborative movement, we are also trying to engage with all participants within Asia, whether it is individual participants or within the perspective of formal organizations or institutions or maybe NGOs. So, what we are trying to perceive here as well is that we are trying to get certain perspective rather than the perspective we already have within the memberships of A3T. So it is a very pleasure to meet you all once again, and here in our third day of webinar to commemorate the International Prevention Torture Awareness Month. If I actually said that correctly, because it has a lot of variables within that international day. Today we're going to focus on medico-legal documentation. But maybe before we move on to our speakers, a brief about medico-legal documentation is that several cases of torture has actually been not really unboxed or unpacked because it has certain documentations that is not really documented either well or is not really published by certain communities or certain organizations. But in reality, this documentation is very important for us to know maybe the flow, or maybe we know the nature probably of torture within the countries of Asia as a whole, or within certain specific perspectives from each country. So without further ado, we have three speakers for today. We have James Lin. He's from the IRCT. Hi, James. And then we have Dr. Wasti from Nepal. And then we also have Adele from Medical Action Group Philippines. And so, in this discussion, participants for tonight, we have three sessions of presentations from each speakers. And here, each speaker will be given 10 minutes to present their materials. And after we have, so it's 3 times 10 minutes, we have 30 minutes of presentation. We will then have a very probably and hopefully fruitful discussion and Q&A session for the next 10 or 15 minutes. So without further ado, for Mr. James Lin, Honorable James Lin, I will give you the floor so you may have your presentation. Thank you so much.
Thanks a lot, Nadine. And it's great to see everyone. I just have to, I just warn everyone first. I just got off like a 28-hour flight, and literally like got into the hotel like 5 minutes ago. So I'm going to try to make sense, but I can't promise. so yeah, so I presented some slides. I'm going to put it up, but I just wanted to begin with the idea. And note that, you know, we keep using this term medical legal documentation or forensic documentation. And with it comes a lot of glamour and expectation in some ways, and a lot of pressure as well. But I think it's important to remember when we say medical legal documentation, what that really means, right? The meaning of it is simply the documentation, the use of medical or psychological evidence in legal proceedings. And so there are several things that entails. One is the collection of medical and psychological evidence, not necessarily, and I'll get to that in 1 second, but not necessarily by medical doctors or psychologists, but simply to collect evidence. Very often that can be done by lawyers, activists, and others, and then to apply it to the legal system, which requires, and I think this is the challenge in it, which requires an interpretation of this type of evidence, right? To understand how then, what is the relevance of it in a legal perspective? Right? What is the relevance of an individual in PTSD in a legal perspective? How do we demonstrate that the individual got PTSD based on a specific act of torture? And how do we express how that PTSD affects the way that individual engages with the legal system, engages with judges, engages with prosecutors, engages with defendants, engages with the lawyer themselves? Right? What makes this forensic is the actual application of medical information into the legal system. And that's where the challenge is. And that in some ways, I think that is in many ways where the focus has to be. Right? So it's not just, you know, taking photos of scars or lesions and other things, but it's understanding then how we put it all together to be palatable, right? So that the legal system itself can understand it. So judges, prosecutors, and others can connect it to the specific criminal elements that they're trying to identify. I was asked to provide a few comments about the Istanbul Protocol. And as the beginning of this, so I just have a few slides to provide. And then I'm hoping to actually show a couple of tools that the IRCT has recently developed just in the last several months to facilitate or encourage civil society individuals and activists in how to basically guide them in how to collect medical and psychological evidence within their capacity. Mm-hmm. So let me put this up, I guess. Sorry, like I said, I just got off the airplane, so this is more challenging than it has to be. Okay, so everyone can see this. This is the Istanbul Protocol. For those who don't know, the Istanbul Protocol is the United Nations Manual on the Effective Investigation and Documentation of Torture and Ill Treatment. It's considered one of the key international standards, or the key international standard that should be applied. And it's simply the international standard on how you conduct effective investigation. Which means that it's the measurement for it. So states have an obligation to conduct effective investigations under the Article 13 of the Convention Against Torture. and to conduct 11 and 13, and to undertake these investigations when reasonable grounds exist to believe that torture has been committed. Meaning reasonable grounds not requiring a specific allegation, but an individual is in prison, they show up to the, you notice that they are bruised, and those are reasonable grounds to suspect that some kind of injury may have occurred, that the authorities may be responsible for. So this is a photo of waterboarding. We know this photo is fake. How do we know this photo is fake? We know this photo is fake because no one has ever seen a photo of real waterboarding before. Because individuals who commit waterboarding in places that commit waterboarding don't take photos of it. So after an individual is waterboarded, this is actually out of a protest from Washington, D.C. And what's important to remember then is, why is medical legal documentation so important, right? Why do we say the Istanbul Protocol is so important? Because the only evidence of waterboarding that exists from the individual following this is both physical and psychological. All the evidence that you have of waterboarding is from the individual themselves. No other evidence exists that individuals that you will ever get access to. And that's the way that all of torture is. Again, we have, this is from a presentation by Amnesty International. And we have here, all the different methods of torture, right? The point of the Istanbul Protocol is to help to take an individual's experience of torture and ill treatment, right? And all the different types of torture they've experienced, where they've experienced, and to take it and to assist or facilitate people in documenting each individual act or each individual experience, and then to collectively understand their experience, to collectively understand, well, in 1 month, this individual was subjected to these 20 different types of torture, different physical acts of torture and ill treatment. And how do we express that together, right? How do we take all of these different acts, analyze or assess them based on the person's physical and psychological state? How do we assess them collectively? Because we know every act of torture and ill treatment, specific acts, they're cumulative in nature, very often physically, but definitely psychologically. So how do we take all of this, assess it individually, and then come up with one singular, comprehensive interpretation and conclusion about the person's experience? And that's really what the Istanbul Protocol is helpful for. This is just an outline of what is in the Istanbul Protocol. There are 6 chapters, 4 annexes. Some of you may know that it has been, in fact, in the process of revision. And next week, we are going to launch, after a 6-year effort, together with the 4 anti-torture committees, bodies of the United Nations, and 4 of the leading NGOs, the IRCT, Physicians for Human Rights, Human Rights Foundation of Turkey, and Redress. We have led a process involving 190 experts in 51 countries to revise this now. And that will be released next week. But this is generally what it includes. And the value of the Istanbul Protocol then is, as I mentioned, as a standard for measuring what counts as effective. States, many courts and other international, regional, and national bodies have held that an investigation that does not follow the Istanbul Protocol cannot be considered effective. So that is what the Istanbul Protocol is for. But the other value is that it provides a basis for discussing or talking about the medical and psychological impact of torture on individuals, right? A holistic and internationally accepted minimum basis of what the impact of torture is, what should be qualified as torture, and in fact, as well, establishes responsibility of stakeholders to address it. You'll notice, if you've seen the Istanbul Protocol, The existing version is about 80 something pages. And I will apologize first because the new version is something more like 200. And I know Adele is unhappy because Adele was trying to, Adele was for actually trying to make the 80 pages, 40 pages. And I have to be honest, I sort of was as well, but this is what happened. But the reason why it has grown so much is because within 20 years, we have learned so much about how to document torture and understand it. The legal standards and our legal understanding of what torture is and how it affects individuals. And so what should be qualified as torture has changed. And as well, the new Istanbul Protocol, in many ways, it's like a lawyer's dream. Protocols are only as useful as when they are used. So very often, even with the current Istanbul Protocol, we have been in a situation where people wonder, well, my country hasn't adopted the Istanbul Protocol. It's not in any policies. So how can I reference it in my legal advocacy? But the reality is, I mean, it is an international standard that is well understood or accepted as an international standard. Until you begin to use it and to reference it, it will never gain recognition in the national system, right? So that is the utility of it. And now the new version of the Istanbul Protocol, which is much, much longer, in many ways, any argument that you have ever wanted to make about torture and ill treatment, about its effects on individuals, you will be able to find references to in the new Istanbul Protocol. So what we have done is just expand the guidance to make clear what many of us understand about torture and ill treatment and have been trying to argue to courts and legal proceedings all of these years. What's an example of that? For example, issues of memory, right? And the fact that victims may have challenges with remembering events, that they have difficulties with expressing their narrative in chronological ways, right? And so all of that is in the new Istanbul Protocol. Now, I mean, we have some basic principles. You can look those up. No physical signs does not mean that there wasn't torture. No psychological signs does not mean that there was no torture, right? Those are the two core principles of the Istanbul Protocol. And I would just note, but I've mentioned this before, in documentation, as you'll hear from Adele and Dr. Wasti anyways, what we document is the method or the act specifically of the individual, the effect of torture on victims, and then the effect of the trauma and injury on victims, right? So how does the actual, the trauma and the injury affect victims, right? How does it affect the way they engage in a legal proceeding? How has it affected their life? Important for issues of reparations, right? And impact. And then this is a little bit more about the new Istanbul Protocol. Now, if I can take just one last minute, well, first, the new Istanbul Protocol, you see there are guidelines now on documenting torture and ill treatment in children, which was something a lot of people asked for. There are new guidelines on documentation of sexual and gender-based violence and documentation of torture on LGBTQ individuals. Now, I guess if you go to the last thing, I would, I'm just trying to stop sharing. The last thing I would just point people to, and then I will get off the floor, is if you go to the IRCT's website, we just published two tools. It's the website is irct.org/protest toolkit. And what you will find are two tools that we developed to facilitate or assist individuals. So individuals themselves, activists and others, and civil society organizations, and how to collect medical legal evidence, right? How to collect medical evidence in a better way. And if I can just, I will just pull up one of these and you can see very easily. So the two tools are these. One is an illustrated guide you see. And it's actually meant to be a guide shared on the telephone, right? And it basically walks people through how to collect these four things, how to take better photos and videos of acts of police brutality. And it guides them in how to do that. There is guidance in how to collect and preserve physical evidence. So basic forensic guidance, right, on this, including, for example, hang drying your clothes, preserving trace evidence, wrapping things in paper. And there's guidance on how to provide a detailed story and how to collect physical evidence. Why this is important is if you read the guidance, you'll notice the importance is it's not only about physical scars and injuries, right? Very often, for example, we fail to, or we forget to ask individuals actually how injuries have affected them, right? What other types of physical pain or discomfort they have, what things they can't do because of the injuries they have. It also guides people in, right, whether or not they got medical treatment after specific injuries, which I know. And it guides people on how to take photographs, right, in the proper way. Taking full body photographs, medium photographs to see the injury or the region of the body, to understand patterns of bruises, and to understand, to take close-up photographs. So I would encourage everyone just to look at these two tools. I will share someone's asked, I can share the slides and I will actually share the tools as well with everyone. But you can go onto the IRCT's website to have a look. But in fact, these are developed for non-medical, non-health professionals on how to take and collect better medical and psychological evidence for application in legal proceedings. So that's that.
Okay, thank you so much, James. Because you said before that you were on after your 28 hours of flight, so you might worry that maybe several materials are maybe passed. But what I actually felt is that I have a better understanding of medical legal documentation now, because if I can have several points of today's discussion from James, is that we now have to understand that medical legal documentation has its urgency for us to understand more and deeper for the pattern of torture, so that certain actors from the judicial process, such as judges, prosecutors, and also other elements, is able to make good decisions from these legal documentations or proofs throughout the psychological and physical aspects. So these are some great points pointed out by James. And he also mentioned regarding Istanbul Protocol. So this is a great guideline to the torture documentations, from certain simple things like how do you actually take a picture from a torture victim, and the certain urgencies to these protocols and the documentation itself. So hopefully from this, for the participants who are currently inside this discussion and even listening to the Contrasys YouTube, I hope you have the same feeling as me, because now I have a better understanding of medical legal documentation in brief. So maybe I would next have the microphone to Dr. Wasti, who has been very, very eager looking at his camera, just like eager to share his presentation and materials. And by that, I would like to give the microphone to Dr. Wasti. And before that, maybe I can help share screen his material. So please hang on a sec.
Thank you very much, Nadine. I like to express a great thanks to invite me in this very important issue. And Mr. James we were together once upon a time here in Kathmandu, yes. So, what was the situation here regarding this issue. But now little bit changes are there, especially in legal provisions. Now we have around 4 years, more than 4 years, we have substantive law, which made the torture as criminal case. Of course, our previous constitution, they had the right under the right issues of the people as basic right against torture, yes, and but that was not implemented because of lacking so-called very general type of just torture compensation act like procedural law. So it is not necessary to talk about how important the medical legal documentation, because very often it is only the evidence. But as James rightly mentioned, that if there is no any visible evidence or traceable, even psychological, one cannot conclude that the torture incident did not take place. It happens in many cases. But people usually from public as well as those law enforcement authority or judiciary, people from judiciary, prosecutor, lawyer, even defense lawyer, they all have that idea that if no any visible sign, it is just a story, fake story, it is just blame, it is just allegation, one cannot prove. But as if it is documented as per Istanbul Protocol, even existing one, and now we are getting the better one, which guides more in depth to collect those evidence, to collect even those statements which have already evidential value, which can be understood by even laymen, people like judges, even lawyers. But it needs skills. So detailed documentation can explore the situation in detention, definitely. Documentation of the history in chronological order. That is the most essential part, with which it starts. Then going to any traceable, visible evidences of physical torture and also psychological torture. But problem here, later on I'll just under challenges also, I can just mention that our Constitution of Nepal 2015, right against torture, assurance of no torture and other inhuman behavior, compensation will be provided if committed. That was already there even in previous constitutions, but no implementation. Please go to next. Our substantive law, go to next. Muluki Criminal Code 2017, which enacted actually since 2018. There is for the purpose of investigation, torture and cruel inhuman behavior are not permitted, with purpose of especially stated like information collection, confession, punishment, creation of threat or fear, and any other illegal activity. If it is committed, it is penalized as per next slide, up to 5 years imprisonment or up to 50,000 rupees fine, or both, according to severity. The clear-cut legal provision in substantive law is here, and also it further mentions that both order giver and perpetrator or executor are liable. So it is also clearly mentioned. In previous Torture Compensation Act, such specific points were never included. Just vaguely it was termed, if it is proved, state can give a reasonable amount of compensation. That was limited with that. And for this procedural law, further it is there, Criminal Procedural Code, which mentions medical examination is necessary. So that is there. in another law, go to next, that is mentioned there. Yes, physical examination of victim of torture by government medical doctor or doctor authorized by government. Previously, government medical doctor only it was mentioned, but in some other institutions, experts like forensic pathologists, they are working, but they are not permitted, or they are not permitted to provide consultation if somebody seeks. Now the law opened that bar. One can seek experts consultation, and then also examination, documentation. And also the same law mentions that submit the medical legal report within 3 days. But it mentions still here is lacking. Only physical examination. In our language, physical examination only. Psychological examination still not included here, which I personally, with our other colleagues and other co-workers, we are in lobbying that not only physical evidences exist in torture cases, many more there are psychological than physical. So, as I mentioned, the problem here is medical examiner or doctors must be enabled. I like to request to IRCT and other organization like A3T. So it is the crucial in countries like ours, especially in Asian context. In developed countries, yes, there are rules, regulations, there are experts, and people are more conscious, more aware, and they can reach to the experts and rightly document it. There is chance. But in countries in developing world, in countries like Nepal, even India, Pakistan, everywhere, even Indonesia, I don't think everywhere there are consultants in each and every district or each and every hospitals. So this issue must be addressed. Otherwise, Istanbul Protocol is there. Even we have developed standard operating procedure passed by Ministry of Health and Population, but not properly till date implemented. We are fighting for that also here in Nepal, where one chapter, one SOP specifically developed by forensic pathologist, including me, and we are fighting to implement that, to have this standard operating procedure in each hospital, and each medical officer must be basically at least have some basic orientation training for clinical medical legal work, because torture victim examination comes under clinical medical legal work. So we are also fighting on that, and keeping this chapter in medical curriculum also, that is essential and lacking part in medical colleges or universities curriculum of this continent. Not all universities, not all medical colleges have sufficiently incorporated to elaborate, to give basic idea for medical graduates, because from the beginning they must be aware. So to become consultant, there is other speciality, and they go forward. Somebody might deny not to conduct any medical legal documentation, only to treat patients, to perform surgeries and so on, only for therapeutic part. That is another part. But somebody, some doctor, some medical examiner must do this, so they must be enabled. I should not talk about Istanbul Protocol, because more than enough for us for today. James already highlighted it. So from the beginning, I personally, as before being a specialist in this field 30 years back, I used to apply this. And I visited as expert witness in Central Court of London from the case of Nepal. So their defense lawyer first asked me, Dr. Wasti, did you follow the Istanbul protocol while making this report? That was the first question. But from the beginning, I used to apply this. So for me, it was not a problem. As per my best of my knowledge, I tried to make it more complete. But it was very old case. So because of many reasons, the torture committed to that individual, those individuals was proved. But the allegation against the specific perpetrator could not be proved by prosecution. So he was released by even international court. So there are still challenges for us, for especially for clinicians, for doctors, for medical examiners who conduct this issue. You can go forward. I like to show few photos done by myself. So regarding Istanbul Pro, that is already done. So just for a doctor, the injuries, those are bruises. That's all for a medical doctor. But a doctor having basic orientation regarding the issue of torture, so it is a big something like textbook, because location of the injury, nature of the injury, color of the injury, showing when they could be produced. So with that extent, a medical doctor must document and properly photograph, as James rightly mentioned. So one case brought before me for autopsy. And there was just saying by security personnel that he was the suspect, he was arrested, and he was transported through a vehicle, and he jumped from the vehicle. Then we opened fire. Unfortunately, he died. That was the story. But there was firearm injury as cause of death over the head, single firearm injury, but over the body in different part. Yes. So as Istanbul Protocol guides that taking the history properly, and the whatever finding you have, whether they corroborate or not, whether there is something like relevancy with that statement, with that allegation, and compatibility with the finding or not. So if with that angle, even one doctor or even one layman, even farmer can say that such injuries, only such injuries are impossible if one jumps from a running vehicle, yes, over the road. So the specific feature of the injury which must be identified, a medical examiner. The person may not speak even, but the story is, the findings are telling the entire story. There are similar photos other, if you go further, which are some specific feature and only present in situation of deliberate infliction of injury, intentionally inflicting the injury, sign of repetition, very commonly using the blunt force, yes, and similar nature injury over the body. You can quickly skip few other photographs, like those hidden area, unlikely by any fall, and different part, front side, back side, lateral side, right side. If one tries to fake the story, even in old cases, if there are lesions, those can be documented. Like here, a burn scar after many years. It was just drawing with hurt object. How much inhuman, how much cruel the work. One can just imagine. So, but the medical examiner must have some basic orientation regarding the issue. Repeat sign of repetition like this. Unlikely be any accidental fall. And especially those objects carrying by security authority, sticks, typical tramline pattern injuries, those are characteristics. And over the sole, which are they think that is not visible, those are not visible. But if it is extremely done, even this is fatal case in autopsy case. The person kept in custody only about 36 hours. Within 36 hours, so brutally beaten up to death. So we examined entire part of the body. Now coming to challenges. Delay in examination usually definitely reduces the chance of visible finding. Not always we can find. I examined more than 500 cases, and probably for a doctor, only torture victim more than 500, it is huge number. Because of this situation of conflict in our country, 10 years. So those days, many cases. Nowadays, definitely reduced, not such big number. One or two cases per month, they come in our center. And the problem is delay in examination decrease the chance of visible finding. Again, documentation of the history by the examinee, or if sometimes examinee may be disabled people, may not narrate properly, their guardian, and sometimes children also. I got a 7-year child with phalanga, beating over the shoulder. 7-year child, also electrocution applied. The mark of electrocution, you don't see if even immediately you examine, those are not always visible. Immediately also not visible means there is only history. So how you give opinion? For this you need definitely a detail, not only a simple orientation training. So medical examiner must be trained. So untrained medical examiner, and just for there is doctor in hospital who does everything. Medico-legal, other therapeutic, other clinical, even minor surgeries, everything. So it is the big challenge in our countries. And fear psychology in torture survival. Even not in conflict time, in normal situation also, that fear psychology makes the survivor to hide the issue. They are not open. They are not telling the truth. But if there are some physical finding, those findings are telling, and they are lying. We can understand. So those things must be explored. So those can be done only by trained medical examiner. And psychological assessment and documentation due to lack of trained, of course. Here our psychiatrist, in the same case where London court called us, one senior psychiatrist who not only examined, who treated case for years to those survivors. But when court called, because of fear of court, what will be asked, how should be answered, psychiatrist, consultant psychiatrist, retired from government job, working more than 30 years, 40 years. So that is the situation. So that's why forensic psychiatry, one of the specialty who could do the job by better way, the best way, but we are lacking those also. And now the perpetrator's trend is less physical, because physical by this or that way visible and can be traced by even general medical examiner, even non-specialist, but psychological they cannot trace. That's why they started in Nepal. Here torture is not so drastically reduced, but the modified, more psychological than physical. So these are the challenges, and main thing is I like to focus for organization who are responsible, who are working in this sector, who are raising the voices for the betterment, for the improvement in documentation. medical examiner must be enabled. That's my view and also experience. If any queries, I'll take part later on. Thank you.
Thank you also, Dr. Wasti, for telling us several important things regarding medical legal documentation. So here what I have noted several presentations from Dr. Wasti is that first is the importance, again, highlighting the importance of medical legal documentation within torture cases. And so if the question is it important for us to highlight this? Dr. Waspi, again and again for each slide, he said, yes, it is even very important because what I can see, the red string is that from James and then from Dr. Wasti's side, if we want to abolish the number of torture, then we need some real proof here, whether it is psychological or it is physical proof. And one of the things that should be done in order for this to happen, in order to abolish torture acts and etc., is the existence of medical legal documentation. And here, I also took notes that it is essential for us to do this to strengthen our medical legal documentation in order to provide justice for the survivors of and victims also, or victims, sorry, of torture. And the next thing is that Dr. Wasti here also stated several things that are done within the either security forces or other actors that are the main perpetrators of torture is that they tend to also use now psychological abuses. So it is also actually maybe a challenge. If Dr. Wasti mentioned before, it is a challenge for this medical legal documentation and should be addressed as soon as possible by other stakeholders to strengthen this issue. So I also took note that Dr. Wasti stated here, it is crucial even for the countries like us, quote unquote, within Asia, to strengthen this issue, starting from strengthening its legal documentations itself. So I think it's those are the several important parts that I have taken notes from Dr. Wasti. And maybe now, last without least, before we went on to our discussion session, I would like to give the next microphone to Miss Beautiful Adele from Medical Action Group Philippines. So without any further ado, I'll just give the floor to Adele. Please do, Adele.
Thank you, Nadine. My presentation is about how the results of the use or the application of Istanbul Protocol. So, can you see the?
Yes, it is presentable. It's okay, Adele.
Okay, thank you. So next. So the same in other countries. No, torture persists in the Philippines despite the judicial and administrative legislative measures. Also, together, same with Nepal. No, it is anti-torture law is mentioned in our constitution and it is prohibited. And we also is a member of or acceded cases of torture or UNCAT, and there is a law against torture, which is enacted in 2009. So, as I've said, my presentation is on the use of Istanbul Protocol, especially in Manalo case, so Manalo brothers. No, it's they are brothers, and it's the first time that the Supreme Court, or it is the Supreme Court who come up with the decision in the citing Istanbul Protocol is very relevant to the case of two brothers who was disappeared and eventually surfaced, and they filed the writ of amparo And so that is the case of the two brothers. But because of the Istanbul Protocol, they proved that they were uh, disappeared for 18 months. So the same with this Banalo brothers was abdicated and abducted or by the uniformed men, and then allegedly they were members of New People's Army, and then they transferred to 5 places before they escaped from that last uh, military camp in 2007. So we also document, here are some of the documentations done. You can see it is really a case of torture, and they were and the when our doctor examined it, it was already 18 months. The scars were already healed as well, but there are some parts that, as Dr. Wasti said, they can be seen, no, or prove to court that they were tortured. And so this is so the families of the victims approached the families of involuntary disappearance or find, and then the medical action group uh, through Dr. Molino is the one who documented this. And so I would like to highlight in this case that even though we do not have, this is the most important, with our anti-torture law is not yet passed or enacted during this period, but it was appreciated by the higher court, and he testified that the Istanbul Protocol was used in the examination of the uh, uh, torture victims. And so it was very important or very significant decision by the Supreme Court at the time. I think I will mention some of the few cases wherein cases of torture was also filed. However, despite the cases like this one, together with IRCT, we do have a project called Forensic Evidence Against Torture, and we document cases of torture during this period. That's after 2009, no? Or 2010 when we documented it. But this time, the prosecutor did not support or dismiss the case of torture, which we filed twice, no, from the Commission on Human Rights and also from the families, no. And also the prosecutor violated the prescribed 60 days, no. So, but meaning he has given his decision after 300 days. So again, the prosecutor says there is insufficient evidence, but later on I will tell you about the decision of the another court. So there is also a case, RC, who was filed a case of torture, but however this is not in this case. The problem here is that those who were perpetrators were using a different names. It does not jive to. So the court asked the military to produce those person. However, since they were not on the list, this case is like a standoff, or it did not won in court because, or the judge appreciated the case of torture. However, there is no perpetrator. Another case is a case of Senior Inspector B, caught torturing by cell phone, and the Department of Justice recommended filing case of torture because it's very the video taken by the somebody was very clear, no. However, again, um, it is admitted as a case of torture, but there is a problem in the family who will file a case of torture, because this victim of torture died from that case, no. Also, another case is um, two friends or two farmers who were allegedly a bomber of a rural transit. And the problem here is that there are two doctors who documented the case of torture. And but this talk the result is that their reports clashes together. They one report said there is a torture, while the other one said no, none. No? So, and here comes our doctor again, a pathologist, and he used IP in his documentation. And by the way, the families filed motion for reconsideration. It was granted by the Department of Justice that it is a case of torture because of the use of IP, and they cited it in the report. And then there's another case. This is an ongoing case. That's why I did not mention the name. This one was severely burned alive. And so there is a documentation in relation to Mr. A. And our doctor again used the Istanbul Protocol to document cases of torture. So in conclusion, no, the Istanbul Protocol was used here in the Philippines, but it it it, it there is no contest or problem in the relation to the Istanbul Protocol as a standard. However, if it is done, if the result is different in different results or outcome from the case, no, as mentioned earlier on, and I should be honest here that we only have one case of torture filed and win in court, and that is filed by with the support from the Commission on Human Rights as well as the Amnesty International. That's why the Medical Action Group keeps on promoting the use of Istanbul Protocol. For example, it made partnership with the Association of Municipal Health Officers, or the public health doctors, which is about 1,400, but we only trained a third of that, or doctors from the emergency department of hospitals, because they were the one who were first received cases of torture in their emergency department. And we also would like to recognize the support of IRCT in relation to drafting a protocol, which is very difficult to do. For it um, uh, to be recognized or to be appreciated by the hospital, they should undergo such protocol. And recognition of case of torture is a difficult one. That's why we are very thankful to IRCT. I think that's it. Thank you very much.
Thank you so much, Adele. I think before the slide ended, there was a beautiful saying from the Philippines to say goodbye. So that's super okay, because in Indonesia we usually say selamat tinggal, or goodbye, or just see you soon, or see you tomorrow. But okay, so several things that have been noted from Adele's side, actually in the perspective of Philippines, but she also mentioned several things such as collaboratively documenting and reporting to several stakeholders, such as the IRCT. This is a very great a best practice for the documentation done by certain actors within Asia and also other countries. Here, I would like to also address that this Istanbul Protocol, this one certain protocol, is actually proven effective and useful in certain cases, which Adele has mentioned in her slides. One of the cases I remembered during the presentation is that one said that there were no torture, but the other one said that there was torture. Whether the outcomes will go back and forth or different in any way, but it is still proven also by these true or real cases of torture, that if we use the power of medico-legal documentation, we cannot deny the truth within legal proofs. So that is a very great point from Adele. And also, not only given an awareness to us that it is effective, but this also raises awareness from the existence of Istanbul Protocol and its uses as well, to make us more aware, and even slaps us with these documentations. It is important for us to see that there are certain pattern of torture within countries which are different from one to another. So I have read, and I have actually also understood several great points from our speakers, but now I have to re-invite them again to the stage. Allow me to pin our speakers, including me, because we will now enter our discussion panel. So, there were certain participants that I won't ask their name, have been sending me messages through this Zoom chat. Actually, personally, I want to ask later on. So, could you give me a space? Well, participants, this is your chance. If some of you would like to ask questions to Adele, to James, to Mr. Wasti, please do raise your hand or just give your question in the Zoom chat box, and I will read them later on. So the floor is yours, participants who would like to ask. We have a lot of participants today, including the participants from the live stream. So, there's already one question from Sun Ling. Thank you so much. Given the widespread use of torture in many contexts, how can we build the capacity of organizations, activists, and etc. to utilize the Istanbul Protocol to prove the use of torture? So maybe I would like to go first from our first speaker, James, and then I will go to Mr. Wasti, and then I will go again to Adele. So please do give us your answers from James.
I just copied into the link the tools that we've just recently developed that I mentioned, which I would encourage everyone to have a look at. I mean, yeah, we have been engaging in and developing tools and doing trainings for so many years now on this very thing, and I think it's just something that just needs to continue and to continue to occur. But it's also I think what's important, which I tried to stress, but maybe not very well in after my 28-hour flight of and 12 back-to-back movies, is that it really it doesn't need to be as intimidating as it is. Actually, there are places where we have been doing trainings. For example, actually, even the lawyers that we have been training in Russia for many years, they will even take they do excellent photos, and they actually even draw lesions very well. And they'll take body diagrams with them to meetings. They will even draw lesions and write details about lesions. And they recently told me even that their work is so good that when they actually ask a forensic expert to provide an opinion, the expert charges them less money, because the work that they have done themselves is so rigorous that it's very simple for the expert then just to provide a expert or medical interpretation based on them. So there are many things that people can do, but really the tools that we developed are a good start in learning how to take better photographs, in learning how to ask better questions. And the tools were very much developed based on our work with different organizations all around the world. And what we saw as the challenges in trying to get good evidence to assess or to interpret. So.
Okay, so that was a great and strategic and methodological answer from James. Thank you so much, James. Maybe we can go next to Mr. Wasti. Dr. Wasti, please.
Question is very comprehensive and so good that the main crux is there. So there, for me, it seems that the states, though they have their legislation, laws, legal provisions, constitutional provisions, everything, but to make the implementation sector improved, it needs still pressure. So number one, the experts should come forward from each country, at least number of experts for this good job. As must be, of course, not really everybody is human right activist and giving up other issue, just running for that. It is not necessary. But to become a good professional or a normal professional, the expert should be, first of all, a bit oriented. Only by degree expert is not expertise. There may be degree, but if there is no sufficient awareness regarding the issue, sincerity regarding the issue, that is not, again, the job becomes non-professional. So that part should be addressed. And another, to create pressure to states, it is necessary. So in our context, many NGOs, they initiated, they made continuous advocacy. So even legal provision are outcome because of those reason also. Not easily it could happen, because states are not so willingly they do this, especially in this developing world, because we know the nature of the politicians, their motive, everything. Yes, so pressure is necessary. Number one, to create pressure to state some other ways, and professionalism should be updated. It comes through professional. I think otherwise, just taking one or other initiation, it is not just possible.
Okay, great elaboration from Dr. Wasti. Thank you so much, Dr. Wasti. I've also seen Gerbert commenting in the chat box that Adele raises her thumb because there is mentioned there her organization, the Medical Action Group from the Philippines. Gerbert also mentioned a bit here that in the Philippines there is a Department of Health order to provide the guidelines. Oh, this is great. The guidelines on the use of Istanbul Protocol in elite of cases of torture and in all public health settings. So I think this is one of the methods of how the Istanbul Protocol is being ratified and also implemented in the Medical Action Group in the Philippines. And here, the MAG had previous and successful engagements with the Department of Health and Association of Municipal Health Officers in the Philippines, and also raising awareness about this and the capacity of building public medical doctors in the use of Istanbul Protocol or IP. So, wow, maybe this has answered several things from Adele as well. So maybe Adele, would you like to add several more points from Gerbert's elaboration?
I have no addition because Gerbert is part of Medical Action Group before. That's why he is saying it now. what he said is all right and all true.
Okay. Yeah, he has stated also in the chat box that he was a former staff of Medical Action Group. So that wasn't quite a surprise because he has elaborated such data and also past experiences.
This collective
And
work by professional. The initiation must be like that.
yes.
Then it comes.
Indonesia is still trying to perceive that. So hopefully the best for Indonesia as well in other countries within Asia. Oh, here I just read in the chat box that Sung Ling commented to all speakers who have answered her question. Thank you all for the clear answers. I am fairly new to this subject, so this is really helpful. So James, Dr. Wastian, Adele, you did such a great job presenting such new raw topic to a new learner. So great job. Well, that's from Sun Ling. So any more participants who wish to ask? The discussion is still open. Are there any participants who wish to ask? Okay, I was about to ask, but it was already stated the urgencies and how do we actually try to urge certain countries to implement these standards, these protocols or the Istanbul Protocol. But actually, I just want to ask one certain question. We can see here that the perpetrators of torture is undeniably done by the government officials, some of them. But what I would like to ask here is that the government has the power to pass the laws, the laws, and then other international obligations to certain countries. But what I would like to ask is that with this power, we don't know for sure that the government could just pass the law and just really implement it in some maybe halfways done. So how do we actually urge? So the question before from Sun Ling is actually for organizations and activists, right? So that is a non-government actors. But how do we actually urge the government to put the medico-legal documentation, especially the method of the Istanbul Protocol, to be a priority? So maybe I would like to ask, I would like to revise this to Adele first, and then go to James, and then we go to Mr. Waspi.
The first thing we did was to intervene in the drafting of the law, and you put it there. Whatever you are advocating for example, you want the practice of Istanbul Protocol and or the development of guidelines in relation to torture, then we will start from the beginning, which is drafting of the law. We don't start advocating for the drafting of the guidelines when it is not explicit in the law. So we start there. Thank you.
So we just go on and urge and make it happen, right, Adele? That's what you're trying to say. Okay, we will try. We will try. Okay, thank you so much, Adele. That is not only an answer, but also a pure motivation for us all. So we will go next to James.
Yeah, thanks. I think it's important to remember, the spirit of the Istanbul Protocol was that it was always meant as, it's meant as a guideline for states, right? It's a UN guideline for states to fulfill their obligations, but it was actually always meant to be used by civil society to measure states, right? Both professionally and legally, right? To assess how they're working. And I think that's very important, actually, what Dr. Wasti even in the last comments mentioned, that nothing prevents states, NGOs from using it, or health professionals. Actually, one of the revisions now is in the new Istanbul Protocol is to make it clear that health professionals generally have an obligation. This is even in the World Medical Association, one of the new recommendations, to detect, to recognize and to learn how to recognize and detect, and then to report torture. So it can be used, and as the professionals begin to use it, it becomes a professional standard anyhow, irrespective of whether or not the state wants to, legislate about it.
Okay. Okay, thank you so much, James. And then, last but not least, save the best for the last, they say. We will go on to Dr. Wasti, so please give your answer.
I agree 100% with James. Professional must come forward because UN prepares very good standards, yes, but UN does not create pressure to state to apply it. Yes, so in modern age, educated people and good professional, medical professional, as rightly mentioned, medical association should take initiation. Not in all countries, medical association, they become happy to take initiation against state, especially for their some limited benefits. They become aggressive also, but for good things like this, not immediately it might come. But the professional society, like Medico-Legal Society of Nepal, we developed standard operating procedure for 6 different medico-legal sectors, including medico-legal autopsy, and under medico-legal autopsy also, custodial death investigations must have some other standards. We don't have national standards must develop till date, but now it is national standard on the basis of international practices, international good practices, and Minnesota Protocol that is there, also endorsed by UN, and state must implement this. That state has obligation for this. Similarly, for Istanbul Protocol also, but usually they don't do. That's why we Medico-Legal Society of Nepal, we are only about 45 forensic pathologists till date in this country, and this number in very recent years, reaching up to this number, forensic pathologist, that is few years back, 3-4 years back only. Otherwise, very few forensic pathologists we were here. So now we developed standard operating procedures for the general injury examination in case of physical assault, in case of sexual assault, examination of the survivor, examination of the accused. So there must be some standards in each and every hospital, by each and every medical examiner, whatever the capacity there, whether just medical officer or emergency medical officer or expert, they must follow this. So we are still, for proper implementation, we are fighting, but at least we experts in forensic medicine or forensic pathology, we automatically apply this. Within us, it is now updated, but to spread it throughout the country for the coverage of each and every case in each and every hospital, the Ministry of Health or Department of Health must implement it. So we are fighting for this, for proper implementation. They never deny, but there is not immediate action for that. Delay. But it happens gradually because time is the important factor. So time, if there is continuous some sort of pressure, and pressure from the other, like NGOs, concerned NGOs who are working in such field, they also must go with some, their action must be purposeful actions for particular issue within particular time frame. That must be done like that. The planning should be by that way. If they assist from outside, from non-stakeholders, and the professional existing inside the country by organized way through their professional society. They continuously hammer. It can be done. I think I'm hopeful in this, though the delay is there.
No delays. That's the thing. No delays, because torture cases kept increasing every day, so we don't really have
Yes.
much time
Yes.
to increase more of them, right?
Right.
Yeah, that's the point. And James also mouthed yes. So I think all speakers agree to this. And this question and also series of answers have closed our today's discussion. But before we close our today's webinar, I would like to hear maybe a closing remarks from three of our speakers. Because I haven't seen Dr. Wasti speaking first, so I will give the microphone first to Dr. Wasti, second to James, and then last to Adele. So please do, Dr. Wasti.
So we discussed very important issue and very, very sensitive at the same time. And it is, I take it in professional activity also one of the most sensitive issues. So thank you very much giving this opportunity and inviting this very concerned, very professional and purposefully working in this field, the people who are here. And I'm happy to meet James after many years. So we were here, we started to do something regarding for the betterment of the forensic field in Nepal. But still you are working in very reputed organization and can do a lot, and you have done a lot, I think, and you can do furthermore. So I wish to your success. And we work together with Dr. Molino also from Philippines. In many meetings we were there. I visited 3-4 times Manila for different issues. And Dr. Molino initiated to make a Medico-Legal Asia network. Yes. So I think he had developed a very good organized sector there in this field. So I'm very happy. Though Nepal is not getting much ahead, but we are also on the right track. But as earlier mentioned, there is no chance of, there should not be any chance of delay, but the delay should be deleted, and as soon as possible the purposeful activities towards the implementation of this of those standards, those guidelines must be done. So again, thank you very much. I also learned many things from those inspiring activities throughout the world. I like to thank for that also. And I heard that the Istanbul Protocol new version that is getting about 200 pages. That is good. Yes, many pages. That is only for non-professional or lazy professional. The big textbook they may bother, but I imagine that is more comprehensive, more understandable, more easily implementable, and that can guide by better way, I think. So we'll be in touch with this also, though I am retired from my regular job, from my government job, but I'm spending my time in medical legal field not I have not jumped to other field. So how much I can work, I continue this, and I'm doing to make this sector better and better, entire medical legal sector, and especially the issue of torture survivor justice. Thank you very much.
Thank you as well, Dr. Wasta. I can see that there's a sense of reunion here in this webinar, and also a form of gratitude and appreciation from one speaker to another speaker. I will go next to James. Please give your greatest closing remark for today's webinar.
Well, I mean, it's hard to add anything inspiring and meaningful after Dr. Wasti has spoken. But indeed, it's really great to see everyone here, and as well, Dr. Wasti and Adele and you and Nadine and everyone else. I don't know. What I would just say is, in many ways, it seems like there's always a struggle, but things have really also changed so much in the last 10, 20 years. I mean, civil society is so much different than it used to be. It's so much more engaged and educated and aware. So I would simply say, carry on. I think we will all get there sooner or later, even if Adele disagrees.
Don't worry, she will agree sooner or later, James. Don't worry. Well, great also closing remarks from James. Last but not least, Adele, I just saw your doggy at the moment and it's not here anymore. Maybe the doggy just represented Adele to give her last closing remark. But Adele, you still have the floor to give our closing remark.
Yes. First of all, thank you very much for the invitation. And second, let us do our roles or job in relation to seeking justice, especially doctors. They have a key role in investigating cases of torture and support victims fight for justice. So thank you very much.
Nice words. What's first from Adele? Thank you so much, speakers. And maybe I would like to give my very, very brief closing remark for today, because we still have eight more webinars to go after this until the 28th of June. So place your bets and grab your seats for our next webinars. But what I want to maybe close for today is that, again, I would like to highlight the importance and the urgency of medico-legal documentation. It's not only a matter of a picture or a video or maybe certain documentations from the hospital and etc. But it is also a legal proof for us to provide justice for the victims and even the families from the victims. Because without any legal proof, we cannot serve something to our judicial process. So medico-legal documentation is it can be inferred as one of our first steps in order to abolish torture in Asia and in specific countries within Asia as well. So I'm Nadine Sherani here as the A3T Secretariat and webinar. I'm going to close the webinar. Thank you all. See you. Goodbye.